Well, good afternoon, everyone, and welcome to the second of 6 sessions in the Providing Healthcare in a Pandemic webinar series. Today's session topic is legal issues associated with telehealth services. I'm Lisa Green, and I'm a program coordinator here at the Western New York Rural Area Health Education Center, or R-AHEC for short. Before we meet our presenter, there's a few things to note. The chat box will be open, so please introduce yourselves there if you'd like. If you have any questions during the presentation, please don't hesitate to type them into the chat. And when you do, make sure that you're selecting to send the chat to everyone and not just panelists, which seems to be the default option, at least on my webinar, so that everybody can see your questions and comments. And also, as always, you're free to leave the webinar at any time. And if you have to leave early, you will be able to access the recordings of all the sessions on our website at r-ahec.org within a day or so of live sessions. Don't forget to visit our website and fill out an evaluation using the link provided. This link is in your Zoom invite too, so you can connect with the eval page using that link as well. And if you have any follow-up questions or would like to connect with one of us at a later time, you can email me at lgreen@r-ahec.org. Phone number there is 585-786-6275. So please don't hesitate to contact me for any questions. So as you know, this webinar series was developed to support our healthcare and service providers who have faced multiple challenges over the last several months due to the COVID-19 pandemic. So today's session is titled Legal Issues Associated with Telehealth Services, and let's meet our presenter, Mr. Scott Carroll. How are you today, Scott?
I'm doing great. I'm delighted to be here and presenting to your group on a very exciting topic.
Agreed. Well, let me talk to you a little bit about Scott. He has 20 years of experience in healthcare and life sciences. He's a partner and co-leader of Lippis, Mathias, Wexler, and Friedman's healthcare practice team. He's represented everything from health plans, medical groups, hospitals, and integrated delivery systems to pharmaceutical and medical device manufacturers, research institutes, and specialty service organizations. He has counseled organizations on complex healthcare regulatory matters, corporate finance issues and collaborations, as well as research, development, distribution, and production agreements. He has also handled large multi-state plaintiff and defense side healthcare litigation matters and civil and criminal fraud and abuse investigations. Prior to joining Lippis, Mathias, Wexler, and Friedman, Mr. Carroll worked as general counsel for a national specialty health services management company, where he was responsible for legal, corporate, and product development functions. Scott was also previously assistant general counsel at Health Now New York Incorporated, doing business as Blue Cross Blue Shield of Western New York, and practiced healthcare law in Washington, D.C. On a personal note, he is a coach for the Buffalo Shamrocks Hockey Club and the Grand Island Soccer Club. So we welcome you, Scott. Thank you so much for being here today.
My pleasure, thank you. And
I'll turn it over to you.
Prefer to be talking about hockey and soccer, but happy to talk about telemedicine and impact of COVID on the delivery of telehealth. So should I go ahead and share mine?
Sure. While he is loading up his presentation, we do have a couple of polls for the audience, and I will go ahead and do that, the first set of polls right now. So I will give you about a minute to go ahead and fill out those polls.
You want me to get started? While we're waiting.
We're going to let a few more people fill in that poll.
Give people a few minutes.
It might give us some information. Okay, I'm going to end the poll. And I'm going to share the results, and Scott, you can take a look at these. Let me know if you can see the poll results.
Great, so it looks like a little less than a third of organizations provided telehealth for services pre-COVID, but over 70% are doing it during the COVID pandemic. That's great information to know. All right,
Okay.
so I'm going to get started. I think, you know, what I'd like to do today in the next hour that we have together talking about telehealth is just to provide a little bit of an overview of telehealth and telemedicine and the kind of legal terms and definitions that are used in it, you know, pre-COVID, you know, the pandemic. And then include, you know, some information about, you know, the legal terms and requirements, you know, that were applicable, but then spend a lot of the time today talking about you know, some overlapping federal and state waivers, you know, that have been adopted either by statute, regulation, or executive orders or administrative actions starting in March, and then, you know, that continue to be in effect now. And then we'll kind of end with a little bit of a discussion about, you know, trends and open issues and what it looks like, you know, might be taking place and is already starting to take place as federal and state agencies evaluate the use of telemedicine and telehealth during the COVID pandemic. Telehealth, and this, you know, refers to the electronic use of electronic information and communication technologies by telehealth providers to deliver healthcare services, which can include the assessment, diagnosis, consultation, treatment, education, care management, or self-management of a patient. And this language is from the definition of the New York State Public Health Law for telehealth. It does not include healthcare services by means of fax machines or electronic messaging. And although they can be used, that technology can be used in conjunction with telemedicine and also kind of store and forward technologies or remote patient monitoring. And we'll kind of discuss what those concepts are in a minute. And under New York definition of telehealth, telehealth should only include audio only communication in rare circumstances as they are permitted under the regulation. We'll see as we get farther along that a lot of the federal and state waivers now permit audio only telehealth communications when, you know, the recipient is not able to do simultaneous audio video communication. And under the New York structure, the definition of telehealth was really established in order to provide a framework for Medicaid coverage for telehealth services. And there's separate statute regarding coverage for telehealth under the insurance law. Terminology that's important in you know, telehealth includes the originating site, which is the site where the patient is located at the time the healthcare services are delivered to the patient by means of telehealth. And New York State Public Health Law specifically outlines those types of facilities that can act and locations that can act as originating sites, which include Article 28, healthcare facilities, which is Article 28 of the New York Public Health Law, and that includes hospitals, diagnosis and treatment clinics, nursing homes and residential healthcare facilities, as well as hospices. Facilities that are certified under the mental hygiene law are also eligible to be originating sites. Day and residential programs that are funded by the Organization for Persons with Developmental Disabilities are eligible to be originating sites. Private physician and dentist offices, adult care facilities, school and school-age child care programs and daycare centers can also be originating sites under the public health law. And of course, the public health law also references the places of residence or other temporary locations of the individual patients that are receiving the telehealth visit. The distant site is a term that refers to the location in which the telehealth provider is located while delivering healthcare services by means of telehealth. Getting into types of technology that are used, a typical telehealth visit is referred basically synchronous, audio visual technology, where both video and audio are used simultaneously to communicate with the patient in real time. Other technologies that can be used and within the context of telehealth and telemedicine include store and forward technology, which is asynchronous electronic transmission of a patient's health information in the form of patient-specific digital images and or pre-recorded videos from a provider at an originating site to a telehealth provider at a distant site. And, frequently this is kind of used in teleradiology, telepathology, and other kind of categories of services where, you have a specialist or, type of provider that is, using these kind of images and information in order to provide diagnostic evaluation of the patient from that distant site location. Remote patient monitoring. This is often not really typically considered to be telehealth, but a lot of times it can be used in connection or in conjunction with telehealth services to kind of assist with evaluation of monitoring of patients in a variety of different settings. Remote patient monitoring is the use of synchronous or asynchronous electronic information and communication technologies to collect personal health information and medical data from a patient at an originating site that is transmitted to a telehealth provider at a distant site for use in the treatment and management of medical conditions that require frequent monitoring. It requires ordering of a physician, and this could include a physician assistant operating under supervision of a physician, a nurse practitioner, or a midwife. It does require, remote patient monitoring, at least under New York law before, the COVID required a substantial and ongoing physician-patient or practitioner-patient relationship. And we'll see the references to the requirement of, patient relationships and other kind of categories of care, as we go through the presentation. But this does kind of show up in areas where governmental programs kind of view the area of being susceptible to programmatic abuse.
So, Scott, what are some examples of synchronous or asynchronous data that might be sent?
Well, I think, with remote patient monitoring, you can have Holter monitors, that's frequently used in obstetrics, and the cardiopulmonary monitoring, heart rhythms or whatever. And it, used to be, you'd have to take the Doppler or whatever, you go home, then you come back, with it or whatever, and they do that kind of monitoring. But I think we're starting to see, more of those kind of monitoring, and then, on an ongoing basis. And then we're starting to see it in the sleep management area as well. Those are just kind of top of mind examples, but before, a lot of the patient would have to kind of use these monitoring devices and then bring them back to the practitioner's office, and then there will be a reading and consultation associated with that. But with the remote patient monitoring and the regular communications between the device on a web service, encrypted method, they're able to kind of get a better, more real-time view of what's going on with the patient.
So are there legal implications if the data is being sent and a provider does not necessarily receive the information or checks it irregularly? Is there legal implications in that situation?
Yes, I mean, and because that information can be PHI if it's unencrypted, or depending upon what the data elements are in that the transmission, the information that's transmitted from the device to the remote location, to the location that's reading it. The developers are able to use technologies that kind of will limit the amount of identifying data that's in the web packet info. And that can be helpful even, but it's also also encrypted. And there will be like a device ID and other things that's able to use, so that there would not be necessarily patient-specific identifying info in the packet of information that's going through the internet. It would, the patient identifying information is really at the site that's receiving the data, and they map it up, to what the device is transcribing.
Okay, thank you.
But all of that does kind of, have to meet requirements under HIPAA and the Health Insurance Portability and Accountability Act, privacy and security regs. And, pre-COVID, there was no differentiation between telehealth and any other kind of communication method. So the telehealth communication methods needed to be structured, and the relationships with the vendors needed to be structured to comply with both the privacy regulations as well as the security regulations.
Gotcha.
Okay. So in addition to kind of traditional telehealth services, there are telemental health services, which is the, as defined under New York law, is a two-way, real-time, interactive audio and video to provide and support clinical psychiatric care at a distance. And again, you can see in the regulations that, the exclusion from that, the ability to do this by telephone conversation or audio only, and it also excludes electronic mail or other kind of correspondence or communication as part of that visit. In the public health law, it does in New York identify specific practitioners and professionals that are able to provide telehealth services, but it's a very, very broad list of professionals, and I'm not going to read every single one, but essentially physicians, PAs, nurse practitioners that are registered professional nurses, RPNs, are able to do in connection with remote patient monitoring. Other doctors, like podiatrists, optometrists, psychologists, licensed clinical social workers, and therapeutic type professionals, which would include physical therapists, occupational therapy, as well as speech language, and educational driven professions, and then the facilities themselves that are specifically licensed under the public health law, which we talked about a little, that can act as originating sites. It would, and although the statute doesn't say it expressly, the guidance from the education department and the other regulators in New York has been that the delivery of a telehealth service or a site by a professional that's licensed under the education law constitutes the formation and establishment of a professional patient relationship. And, even if, it's for one visit or one, or just, it is considered that that relationship is considered to be established. So the analogy would be, it's very similar to, a physician receiving a patient, at an urgent care clinic or whatever for that one retail encounter. That, if I'm having a telehealth or a telebehavioral health visit, with a patient, then it's the same kind of thing. As to that visit, I have established a physician-patient relationship, and all the other regulatory obligations that exist that are associated with that relationship, are now present, which includes the obligation to have consent. It includes the obligation to have adequate records and documentation of the services that are delivered, and the billing and coding has to be able to be documented and verified under that. And you have obviously associated with it this similar malpractice and litigation risk. Turning to informed consent, under the Department of Health guidance, to be a telehealth visit that meets the requirements under their Department of Health. The member must provide consent not only to the service, but receiving the service utilizing telehealth. Telehealth services cannot be recorded absent the member's prior written electronic consent. And there are additional requirements associated with the consent that are required for telemental health. Again, these are the criteria that existed in New York that I'm talking about pre-COVID, pre-establishment of some of the waivers we're going to talk about in a little bit. But, under New York law, there was no, except for certain categories of services under, that are outlined in New York law or in federal law, there is no requirement for a pre-existing relationship to have existed between the professional and the patient in order to deliver telehealth. However, there, for alcoholism and substance abuse treatment, New York required at least one in-person evaluation session with clinical staff prior to participation in telepractice. And then telemental services could only be utilized in personalized recovery-oriented services programs under specific circumstances. And as I mentioned before, remote patient monitoring required substantial and ongoing professional relationship before that was established. In terms of record keeping.
Scott, can I interrupt just for a second?
Yep.
So can you go back to that previous slide? So during COVID, is that rule still in place that?
No, there are waivers for many of these requirements that we'll go through kind of in detail. Some waivers were established on a federal basis, and then with respect to these items that I'm talking, there would alcoholism, substance abuse, and telemental health and remote patient monitoring. There are waivers that are established at the state level.
And we'll go through that later. Okay.
But I think it's important. I just want to make sure people are aware of them, because one of the questions is, what, are these waivers that are being established at the federal level and the state level going to be made permanent, following COVID, because of the usefulness in telemedicine in a number of different areas? And if they are made permanent, are there other areas that they're not going to be made permanent? And the question is, some of these requirements for in-person, or pre-established relationship, are coming from a place where there is some sensitivity to, these kind of categories of care, and past problems and programmatic abuse. And so, it's a open question about, how that's going to show up as, we're listening. I mean, these COVID waivers are going to be in place at least for another, I would assume, another year. I don't, expect that the public health emergency to be, at the federal level or at the state level, to be ended anytime soon. But
Unfortunately not.
we're looking at whether or not these waivers will continue, and CMS has already taken action to make some of the changes permanent. Okay. In terms of record keeping, I think just in the rule of thumb is, not only to have the same level of documentation that you would have for a normal patient encounter, but to also include some additional information regarding the telehealth patient encounter. That includes, the patient's location, the provider's location for the telehealth visit, and the names and roles of any other professionals or persons that are participating in the encounter. And also if we talk, if they're now under the COVID waivers, consent is provided verbally, the nature of the verbal consents should also be included within the record. Online prescribing. The general rule has been that even pre-COVID, online prescription medication and other physician orders and professional orders via telehealth are permissible. However, there are some limitations, and you'll see all the waivers impact those limitations in a few moments. But federal law regarding opioids and the R-AHEC Online Pharmacy Consumer Protection Act, controlled substances can be provided via the internet only with a valid prescription. For a prescription to be valid, it must be issued for a legitimate medical purpose in the usual course of professional practice. And then here's the rub: a doctor must conduct at least one medical evaluation of the patient in person or via telemedicine. It is not necessarily saying you can't do it, but it's just adding a layer of professional standard on top of it. And then for prescription drugs that are used in addiction management, like buprenorphine, I don't know if I'm mispronouncing it or not, requires a preliminary face-to-face evaluation by the Drug Treatment Act Waive Prescribing professional. And then, that is kind of OASIS as child practice standards, that are adopted at the New York State level. HIPAA. I'm sorry, you muted, Lisa?
I said, don't feel bad. Nobody can pronounce that.
So, as I mentioned a little bit earlier, the HIPAA, pre-COVID applies to all aspects of the delivery of telehealth. So, the technology itself needed to be encrypted and private in order to support secure communication between the originating site and the distant site and the profession, and to do so in a manner that does not result in the disclosure of protected health information. And then, the audio, it needs to be, obviously at the originating site, needs to be done in a place that is private and other people can overhear and all that. And then, with the technology vendors itself and that technology platform and channel, you're using a secure encrypted, audio video technology. And you need to evaluate whether or not the technology provider that's going to act as the media or the intermediary for the communication, whether that entity was going to be receiving any protected health information as part of that communication. And if so, you need to have a business associate agreement, with that entity. And then, you need to make, and then there's the other elements of it in terms with consent. And, there are recommendations that, the usage of consent, the consent between the patient and the provider should at least address privacy and security risks. And that those elements should be included within the notice of privacy practices. And if you can see in a couple moments that HHS Office of Civil Rights is waiving a lot of those and providing kind of enforcement discretionary authority during COVID to provide for more permissible, easier pathway for implementing telehealth. The other thing that needs to be considered, need to be aware of, is the state licensure requirements for delivering telemedicine and professional services. And that is, if I'm a provider in New York and I'm licensed in New York, but I'm seeing a patient that's located, this is like a border here. You're seeing a patient that's located in Pennsylvania, across the border in the southern tier. I need to be eligible to provide professional services in Pennsylvania, which can mean that I need to be licensed in Pennsylvania, depending upon the state statute there. And the same goes with New York. If the originating site is intending to use or have a professional at another location to provide services, and that professional is not licensed in the state of New York, then that could be considered outside of absent a waiver that's happening in COVID. That would be considered the unlicensed practice of medicine in the state of New York by that professional that is providing a telemedicine visit. Now, with all the waivers we'll talk about in a minute, that's really not an issue right now, as long as we're going through any kind of credentialing criteria or whatever that the facility might have. But New York has waived out-of-state licensure limitations during the COVID pandemic. But the one thing is after this, we get past this, there is a multi-state compact for licensure that a number of states have adopted that allows physicians and other professionals that on these compact states to get licensed permissively in other jurisdictions in order to provide telemedicine. And we represent some physicians in our practice that have basically licensed in 30 some odd, almost 40 states that are participating in this under the compact because due to the nature of their own telemedicine business. Credentialing and recredentialing. Under traditional regulatory requirements for CMS, for hospitals, and basically their conditions of participation. Professionals that are rendering services via telehealth at a hospital location, even though they might be doing it from a distant location, we're required by CMS to comply with the credentialing, recredentialing standards at that distant site hospital. The originating site hospital. And if the professional is providing services from another hospital or that has a credentialing program and the physician is credentialed under that other hospital, the two hospitals could have an agreement essentially to kind of recognize the credentialing status of the one facility in order to provide telehealth at the other facility. In addition, you have to meet any kind of credentialing criteria for provision of services to that patient that might be present for their own health plan if they have coverage.
Scott, let me break in here. This might be a good time to find out the answers to our second poll question.
Sure.
So let me launch this. I think I can launch our second poll. Okay. Go ahead and answer that poll if you can see it. Can you see that, Scott?
Yes, I can see it.
Okay.
Yeah, and so like here on the question 2 is obviously if you're acting as an originating site for patients, that means the patients are at your location and you're enabling or facilitating a telehealth encounter with another healthcare professional at a distance that is providing services from a distant site. And then in the number 2, where it's acting as, whether your facility is acting as a distant site for the patients. In that situation, you might have, like, for example, if you're a federally qualified health center or you're a rural health clinic or a hospital, you have, physicians there that are providing telehealth from your facility to patients at their homes or to other community or patients located at other community sites, whether home health, or nursing homes or the like.
Okay, so those are the results of the poll.
Okay, so it seems for me is that we have one provider that the patients are coming there and they're hosting the telehealth encounter at their location, and then I don't see that any organizations acting as the site to be the distant site, to be where the provider is when during the telehealth visit, where the patient is in the other originating location. Okay.
Okay.
A word about some medical malpractice risk management considerations in the malpractice risk for telehealth is really at its infancy in terms of developing the body of law around that. And so I think, from a risk management point of view, it's still kind of the best approach is to look at analogous treatment, encounters, and, what the kind of jury verdicts and what the risk is for those kind of treatment encounters, and use that as your guide in developing a risk management approach for telehealth. And say in addition, additional risks that on top of that in telehealth, could be issues that are, inaccurate or substandard validation of the patient's identity, inability, or to obtain an adequate medical history and examination, and that impact on an inappropriate diagnosis and treatment resulting from that. And then generally, if the type of service by telehealth is just not necessarily appropriate, for a telehealth encounter on a normal routine basis, then that in and of itself can generate malpractice risk. Historically, for what we've seen so far, telemedicine services are of a lower acuity on average, and so that has the potential to drive down malpractice risk. But I would say is really in its infancy, and it's going to take some more years before we get a sense of what kind of malpractice risk would normally accrue for telemedicine, let alone what kind of risk is taking place during the pandemic. I would, providers should review their professional liability coverage policies in order to validate that there aren't any exclusions or limitations in there related to that could be construed to cover kind of a telepractice scenario. And then if you're a physician or a provider that in particular is providing services across state lines, and you're relying on state waivers or whatever to do that right now, it doesn't necessarily mean your malpractice coverage is going to cover that if you're providing services across state lines. So, that would be something that you should look at specifically. Programmatic abuse, fraud, and abuse, and still can apply in the context of telemedicine and telehealth. And there have been a couple massive Department of Justice Joint Task Force takedowns that have come. One just last month that nabbed a couple hundred providers across the U.S. And there was also one in the fall of 2019. These areas, the programmatic abuse in not new areas that the government is worried about. I mean, they are areas that have historically been ripe for programmatic abuse. And it's just that the telehealth encounter provides a even more efficient means to generate government programs business and to get, physician orders and referrals than what you would have to do before when you kind of had a mill clinic or whatever in order to get those. And so you're seeing them in opioid pain management, substance abuse, addiction treatment, home health. Home health has always been a real concern for the federal government and state governments for program abuse, and certification and others that are required in the home health visit, and those kind of things taking place remotely do provide an avenue for fraud. And as well as laboratory lab orders, again, is another area that risk. And even with some of these waivers that are taking place to be more permissive, I think what we're going to find is that a year or two, just like you see some of the scrutiny kind of going up now on some of the SBA paycheck protection program loans or whatever, and as they get paid off, there's going to be some more governmental scrutiny. We think that as you get into the next year, into COVID, that you're going to start to see some backward-looking auditing and reviewing of activities and to try to identify fraudulent practices that are taking place currently. Okay, just turning into the actual waivers that have been put in place to kind of facilitate the delivery of telehealth and coverage at the federal and state level and private level for those services. They all tie to federal and state disaster declarations. And HHS has declared a public health emergency associated with COVID-19 and did so in March, and has been issuing and updating that public health emergency every 90 days, and in a numerous number of federal agencies have issued waivers of statutes and regulations using the Public Health Authority under the Public Health Services Act in order to deal with the emergency. I would expect that again these are going to, the public health emergency declarations are going to be reinitiated on a 90-day basis, going forward for the indefinite future. And for even some of the other agencies like the FDA emergency use authorizations or whatever, those are likely to stay in place for a number of years, even after the public health emergency has not been, it is no longer in effect. In terms of there are waivers at the federal level that have been issued by a number of agencies, and that includes CMS with respect to the Medicare program, as well as CMS waivers with respect to state Medicaid programs, so allow the states to do things. And then we'll talk about waivers that have been implemented by HHS Office of Civil Rights with respect to HIPAA, and the HHS Office of the Inspector General with respect to certain program requirements that prohibit beneficiary inducements. So with respect to the Medicare waivers, there's a lot of kind of information in here, and CMS has implemented waivers to generally and across the board waivers, as well as specific telehealth waivers. And the main waiver is that, now, telehealth can be delivered by eligible practitioners, and basically any healthcare professional who is previously ineligible to bill Medicare for telehealth services. It includes physical therapists, occupational therapists, speech language pathologists, and others. Audio only telehealth is permissible for certain services when this recipient does not have available real-time video. Physician supervision, may be provided using live video. Telehealth can be for new and established patients. And at the federal level, to enable to, even though state licensure is a state issue, the CMS billing requirements require that the practitioner be licensed in the state that they're performing the service. So that has been waived. Remote evaluations, virtual check-ins, and e-visits are permitted. Telephone evaluation, management assessment, and management services and behavioral health education services are permitted. Remote patient monitoring can be provided for new and established patients. Okay, and physicians and professionals can they can act as the distance site and perform the services from their home without having to list their home address on their bill. The billing address will continue to be their currently enrolled location. Categories of services that physicians and other federally qualified health clinics and rural health clinics have been increased and expanded. And there is a list of codes that CMS, have the link here. You can go to the cms.gov website, and there's a list of codes that indicates that are codes that are appropriate for telehealth, codes that have been added during the pandemic, as well as codes. It's interesting to me. I've never quite, and we do a lot of rural healthcare, represent clients here, but I've never understood that there was a distinction in the rural healthcare that was permissible to be provided by rural health clinics or federally qualified health centers, but apparently there is. But the coding information at CMS will kind of indicate the expanded authority for these clinics during COVID. Medicare normally has some face-to-face requirements and frequency limitations associated with telehealth, and those have been waived. There have been a number of blanket waiver and policy coding guidance that have been issued by CMS that are available. And there are, you can, at the end of the deck, I provide a list that the Center for Connected Health Policy provides a really good summary of the federal waivers at the Medicare level and at the state level that you can refer to. And Medicare Advantage plans have the flexibility to provide additional coverage for telehealth during the pandemic that goes beyond CMS mandated coverage requirements. And this is outside the normal procedure that a Medicare Advantage plan would have as part of its annual bidding to add coverage beyond normal Medicare coverage. So, Medicare Advantage plans can provide additional coverage for telehealth during the pandemic. CMS has issued waivers for federally qualified health centers and rural health clinics to allow them to act as distance sites for the provision of telemedicine services to patients. Just as indicated, you can refer to the list of the coding changes associated with that. CMS has waived regulatory limitations for critical access hospitals to allow them to partner with offsite hospitals to provide telemedicine services to critical access hospital patients. And then in terms of program integrity related waivers, interestingly enough, CMS has waived a number of provisions under the Stark Law and Stark regulations in order to facilitate the provision of care during the pandemic. And these waivers would apply to relationships between the hospitals and other entities that are subject to START, and physicians that are sources of referrals, which is kind of unprecedented broad waiver for START. The OIG has indicated that it will not enforce the anti-kickback statute or civil monetary penalty provisions that relate to beneficiary inducements related to waivers of cost sharing amounts, for telehealth visits. And then, in addition, this isn't exactly the program integrity thing, but it's somewhat related to this topic. Under the CARES Act that was passed earlier this spring, high deductible plans have, they're required to have a high deductible, and you get a associated account, spending account associated with it. But plans that will still be considered high deductible plans, but they can implement or waive the coinsurance amounts and deductible amounts for telehealth and still comply with those regulatory requirements. Online prescribing waivers. DEA registered practitioners may issue prescriptions for controlled substances for patients who they have not conducted an in-person medical evaluation, provided all the following conditions are met. The prescription is issued for a legitimate medical purpose by a practitioner acting in the usual course of practice, and the telemedicine communication is conducted using audio-visual, real-time interactive communication, and then the practitioner is complying with all other elements of federal and state law. The HHS Office of Civil Rights has indicated that they will waive HIPAA enforcement associated with provision of telehealth during the pandemic. So all those steps that I talked about earlier in terms of business associate, evaluate, kind of consents with your patients, make evaluation of the security and technology of your platform and whether or not they get PHI. All those are essentially not applicable for now. What the guidance does say is that you cannot be using a public facing technology platform. So like Facebook Messenger, Instagram, and some of this is like super obvious, like why would anybody use that for telemedicine? But the guidance specifically does permit Google Meet, Skype, the FaceTime, with the iPhone, and many, the vast majority of those platforms are encrypted to begin with. And Zoom has a telehealth platform, for example, and Microsoft Teams. Although HHS doesn't require during the pandemic, the provider to obtain a business associate, many of the providers of these kind of portals and the communication methodologies do provide a business associate to their organizations that are subscribing to that type of plan. So you are able to get a business associate now, but you're not necessarily required to do so. Getting into a number of waivers that have been implemented by New York State related to provision of telehealth during COVID. Governor Cuomo implemented a executive order that basically waived any of the restrictions in the public health law that were kind of defining acceptable modes of telehealth or telebehavioral health, store and forward or remote patient monitoring technologies in order to facilitate and to the extent necessary to allow additional telehealth provider categories and modalities and to permit other practitioners to deliver services within the scope of practice during the pandemic. The Medicaid program, New York State Department of Health, and other agencies that are responsible for specific categories of care that are covered by the Medicaid program have provided detailed guidance associated with what is necessary to obtain Medicaid coverage for providing telehealth services, expanded telehealth delivery of services to patients in these programs during the COVID. And as indicated by the governor, it does waive a lot of waive a number of requirements, and then provide guidance and recommendations that practitioners and institutions can use in delivering telehealth during the pandemic. And then there is a specific guidance that have been established for a number of providers that are, provide services to special need populations, and including the Office of Mental Health, the Office of Addiction Services and Supports, or Office for People with Developmental Disabilities, and Office of Children and Family Services. And then there is specific guidance for specific, adult social daycare programs and home and community-based services and similar kind of categories of services that we're usually, providing in very hands-on, either day or 24/7 type settings, but that because of the COVID really impacted the ability to provide services in that method in using of telehealth and telebehavioral health and other services on a kind of support delivery in a safe way. And then in addition to this kind of program-specific, Medicaid program-specific waivers and guidance, the Education Department and their executive orders, there has been waivers of professional licensure requirements. Basically, physicians and other medical professionals, licensed outside the state of New York may provide professional services in New York State, including telehealth. If they have inactive registrations, and they are permitted, but they were licensed in New York, but their inactive registrations, they're permitted to provide services. The scope of practice has been expanded to recent graduates from medical schools can provide services under the supervision of licensed physicians, and foreign medical graduates with at least 1 year of postgraduate training are able to provide services under certain circumstances. And then a whole category of professionals that are licensed in Canada, in the provinces of Canada, are able to provide services in New York. And then the New York State Department of Financial Services has, we talked about Medicaid, but with respect to private coverage, for telehealth, the New York State Department of Financial Services issued an emergency rule and circular letter in March, and that rule has been made final through notice and rulemaking. And essentially, New York had a telehealth parity statute to begin with, which said that if it could be covered in an in-person setting, it could be covered telehealth as long as any other legal requirements were met. And then now with the final rule, basically there's a limitation on the ability to charge co-pays and co-insurance during the COVID emergency, and telephone services so the audio communications are now considered telehealth for the purposes of private health insurance coverage. And then payers are prohibited from implementing any additional credentialing or recredentialing requirements in order for a professional or facility to provide covered telehealth services. Looking at, discussion about immunities. and whether or not any of the kind of immunities that exist in federal state law are relevant to telehealth. The the main immunity that is just at the federal level that's associated with providing healthcare during COVID is under the PrEP Act, and that basically protects covered persons, which includes treating professionals, from liability or losses relating to the administration or use of covered countermeasures against COVID, in treatment of COVID-19. And then, and that could, basically anything that's been used, that's got an emergency use authorization by the FDA in order to treat or diagnose, treat, or manage COVID is considered a countermeasure. Any kind of qualified pandemic product or security countermeasure or respiratory protective device that is approved by National Institute for Occupational Safety and Health, and those are kind of the the masks, the respirators, and so it's can be applicable and helpful if the telehealth visit relates to specifically using your diagnosis and you're treating COVID, or you're ordering a test, or you're ordering something that's an approved countermeasure, but it really doesn't provide any kind of broader immunity. And then in New York has enacted and then revised the New York State Emergency Disaster Treatment Protection Act, and that does provide much broader protections to healthcare facilities and professionals from any damages or harm that can sustain a result of an active omission in the course of providing services. If you're providing services during the COVID, the COVID emergency, and the act or omission occurs in the course of providing health services, and the treatment of the individual is impacted by the healthcare facility's decisions or activities in response to or as a result of the COVID outbreak. And we don't know what that immunity is going to end up providing, and how broadly, but it does appear to, if what you're doing has been impacted, or and the services have been impacted by COVID, it seems to provide some sort of immunity for what you're delivering. I will tell you that this language was revised in August or so from the original language that was passed by signed by the governor, which was broader. And there's really not any litigation. There's been litigation filed, but nothing, that I could see in terms of, actual interpretation of what the statute means. And then, as it kind of, in terms of, I would kind of go through, any questions or concerns or whatever that, that we can kind of answer or talk about today. And in terms of next steps and trends, there are a couple of things that are kind of, I would mention. One is, use of telehealth in, delivery of care. In the data that I've seen looking at it recently was, substantial increase of use of telehealth during April, May, or in, the really early stages of the pandemic. But that, from the data that I'm seeing, that seems to have tapered off in terms of physician professional telehealth encounters on a national basis. And there's CMS data, and there's other data that was released by HIPAA from their EHR aggregating info. So we I don't know if as we get in the fall and some prevalence of COVID goes up, whether we'll see greater usage of telehealth. But that was pretty broad look at the data. It wasn't looking at it from like specific modalities or whatever that might be more appropriate for use for telehealth on an ongoing basis. And then what we're also seeing is CMS is already starting to look at ways to make final some of the waivers and on an ongoing basis so that it wouldn't just be pandemic specific type waivers. And we're starting to see some discussion about areas where finalization would be appropriate. And there are some folks that think you should have a broad across the board finalization of the waivers to allow as much telehealth as possible. And then there are other public health policy folks that think it really should be based on kind of evaluation of data and evaluation of need, and that the fee schedule approaching for telehealth and telepractice should somehow be adjusted to take into account some of the inherent inefficiencies in that model, in terms of overhead as well as throughput. So, but it's again, those discussions are really at the early stages. And what is interesting to me is I've been looking through all this stuff to kind of prepare for this presentation, and I haven't seen a lot of chatter or discussion about areas where telehealth and telemedicine has just not done well. And I'd expect that there should be more discussion of that, and there should be more information about whether you're trying telehealth in a number of different practice settings with different populations. And I think it'll be good to see data that's kind of drilling down and seeing how it's worked in those categories of care. Areas where the patients really kind of do need intensive support. And the states are trying to step in and make sure that it's happening. But happy to take questions.
I did have a question in the chat. Mark Massing from R-AHEC asked, would there ever be justification for recording of telehealth sessions for audit use, or is using telehealth software platform logs sufficient enough for audits?
Oh, and I think that's kind of a real sensitive topic. I think it's I think if you do it, if it's to be done, there would need to be, a specific advanced consent. And, I would want to make sure that the patient actually knows about it and then has the option to opt out. And I think if you do that, it's potentially permissible. And there are certain categories of care like psychiatry and behavioral health where that would be very sensitive. And I know that some of the trade associations have issued some guidelines for practitioners in this area about that topic. I can understand, and I think that if you can consider what are the risk areas that you think you would want to record it to prevent, to deal with, and evaluate whether there are other kind of technological solutions that you can use to do it rather than just recording. But I think you'd have to look at the specific category of care and the type of encounters you're looking at to make sure it's permissible if you're going to do it. And then you have to absolutely make sure that you have prior consent associated with that.
Right. In regards to prior consent, is there more leniency in the platforms for consent, as far as, if you're doing telehealth, can you get verbal consent through that interaction?
Yeah, I think, from some of the guidance that we've seen at the state level, there's no federal guidance that saying you can get, verbal consent. It's really at the state level now. And Medicaid is kind of, but even if you have verbal consents, obviously you need to document in the record that you've received, the verbal consents that have been provided.
Lorraine Hanson did have a question. She's asking, in regards to the next steps for making telehealth accessible even after the pandemic is over, do they have a task force looking into it? Are they using feedback from actual providers? And is there a way to be included in that conversation?
I'm not aware of any specific task force that's focusing on telehealth.
That's a great question.
I mean, there's certainly, the current administration has, a task force. And then, obviously the future, if, assuming there's a different administration, but, they have a task force. And, the kind of delivery mechanisms are, on the kind of the radar, but I'm not aware of any specific task force, cross-agency task force focused on telehealth specifically. I would
there
expect
be a way?
Go ahead, I'm sorry.
Would there be a way for providers who have some good feedback or some good comments to make? Who should they contact if they want to be part of a conversation? Even though there's no task force, there's got to be a way for them to let their voices be heard.
Right. Well, there's an American Telehealth Association, and then there's the Center for Connected Health. And, those kind of are two entities that are kind of front and center on that. And I also expect, the other kind of healthcare trade associations to be focused on it, whether AMA, American Hospital Association, and, interact on that. I do think that there will be some legislative, because, again, CARES Act, there are already federal bills that are being implemented in Congress or to be introduced in Congress to deal with telehealth and kind of solidify some of the stuff. So one of the initial things I expect to see is more legislative activity at the committee level for sure. Not necessarily in duck session, but next year, early next year. And like I indicated earlier, CMS has already taken steps to make permanent some of the changes. There have already been some, steps that are being done as part of the fee schedule rulemaking process. There are comment letters and things that are being submitted in connection with that. But I think it's a great question about whether there's kind of a joint task force, whatever, focused on telemedicine. I'm not aware of any.
I had a question that I don't know if you can answer or not, but can you see a day when telehealth services will be mandatory to obtain, a license to practice medicine?
Can you repeat that? I was focusing on the chat and I wasn't listening. Sorry.
Oh, can you see a day when telehealth services will be mandatory to obtain a license to practice medicine?
Where they would like, no, like you'd have broad state licensure to do it, or?
So if you're going to practice medicine, if you're going to set up practice, put your shingle out, you would have to offer telehealth services.
Oh, it's mandated.
See a day.
Like a condition of participation.
Yes.
Yeah, I would see that. I think it will, the way it would happen, that would become part of the standard of care. And the analogy would be now, the standard of care for practicing as a physician is to have adequate call coverage. And, you have to have 24/7 call, and what that means might be a little different if you're a heart surgeon than it might mean if you're or if you're an obstetrics and gynecologist and you're dealing with delivering babies, but if you're a internist or a primary care physician, it's a little bit of a different what that means changes a little bit by specialty, but there is absolutely that expectation of availability. And then you have, concierge practices or the like that, have that concept of instant availability, and that's what you're paying for. I think so. I think that over time, the expectation of what that call coverage might mean or availability might mean as the basic professional duty could change and then start to include the ability to deliver telehealth when necessary. And I see that, but and then I see you're also seeing like, well, health plans or others that are consumer-facing organizations, but require practitioners to meet certain standards to be part of their network or to be part of their delivery infrastructure might start to mandate it. And then I think, and then, you see is that groups and consumer-friendly kind of practitioners are making it a component of their service, that is visible and differentiated.
Right. I don't know if you can see the chat, but Lorraine had another question along with her question about the task force. If telehealth becomes mainstream for the long term, what types of training would you recommend be developed for providers?
That's a great question.
It is.
I think my understanding is that the medical schools are starting to provide training on telehealth. We do work with a lot of folks over at the Jacobs School of Medicine here in Buffalo. I might ask them what they think on this, but I think that some of this goes to some of the nature of the art, and how do there's a lot that goes into that in-person encounter, where the practitioner is getting a lot of info, and they're doing their exam, and there's just so many. You can see there's so many different ways to try to recapture that, even if it's being done remotely. And I think so given the practitioners the understanding of all the different methods that are there now and that are in the works, to be able to just make it even more powerful or productive encounter than just me holding up my phone and having a FaceTime video encounter. And the technology that is being developed, that's going to augment that physician patient encounter is really at its early stages. So I think you're really teaching the practitioners now how to best use that technology and associate with that, to make sure that they're getting the info they need in order to meet their needs, and evaluating that patient and diagnosis and coming up with a treatment plan. And then that's not going to expose them to malpractice risk, but and hopefully can provide at least the same level of outcome, if not improved outcome, with that. But I think it's a great question, and so I'm going to talk to some folks over at the school and see what they say.
Great. Can you give me the two organizations that you helped answer that question again? The question about a task force, you had mentioned two organizations that providers could become partner with or become a part of or contact.
Yeah, and then that is the Center for Connected Health Policy. And I believe the other one is the American Telehealth Association.
The American Telehealth.
Yeah, I can confirm that. Yeah, the ATA, the American Telemed. Sorry. And they've submitted some comment letters on things recently, and that kind of is good way to look at and identify what some of the current policy issues are from their, their perspective.
Well, I want to thank you so very much. If there are any other questions, please feel free to write them in the chat, and you can contact myself and I can get a question to Scott. If you do get some answers to that other question, Scott, we'd be glad to send that out to our audience. They already have your PowerPoint presentation, so thank you for that. And again, thank you so much for joining us today. We really appreciate your expertise. There was so much information in there. We'll have to go back through and look through that PowerPoint a couple more times. But you have a great day, and we will see you another time.
My pleasure. Absolutely delighted to be able to present to you and your group. Good luck with everything you guys are trying to accomplish. And if there's any way we can help anybody, just let us know. We'll do what we can.
Thank you so much.
Thank you. Take care.
I am going to share my screen again just to remind you about next week. Next week, we have a different topic: how to counsel parents on parenting during a pandemic. We have a panel of presenters, which includes Linda Frank, Kathy Severing, and Christy Moscato. And we hope to see you then. Have a great afternoon. Thank you so much.